Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado, and welcome back to All Up in Your Business. On this episode of All Up in Your Business, we're going to talk about making changes or amendments to your trademark application. What you can change, what you can't change, and what you maybe might be able to change. But first, don't forget to like, subscribe, and share, and check the description for links to additional information and resources. All right, so let's say you've just submitted a trademark application with the United States Patent and Trademark Office. After you submit it, you realize, ooh, shoot, I made a mistake. I put my address wrong. I typed in the trademark itself wrong. I put the wrong goods and services descriptions. Or maybe something has changed in your business. Whatever the case may be, maybe you need to make some kind of a change or amend your trademark application after it's already been submitted. Now, sometimes we can make some of these changes really easily, and it's not going to be a big deal. But sometimes we can't make certain changes, or as with most things in the law and trademarks, it's going to depend on the circumstances. Just generally speaking, in order to make an amendment or change something on your application, we can typically do this by using the voluntary amendment form in the USPTO's form bank, and you submit this electronically through the TEAS system. This form is best to use if your trademark hasn't gotten to the phase where it's approved for publication. So maybe it's been assigned to an examining attorney, the examining attorney has looked it over but hasn't yet approved it for publication. If it hasn't yet been approved for publication, or gotten further in the process, then typically this voluntary amendment form is going to be the best way to make some change with your trademark application. There's another voluntary amendment style of form to use after it's been approved for publication, or if it's already been published, or even if the trademark's already been registered. There's a different form for that. Or many of these changes we can make in a response to an office action. So if the examining attorney has issued some kind of an office action, you can respond to that office action, whatever the issues are, and along with that response, you can often indicate if you want to make any other changes in that response to the office action form. So what are a couple of things that we can relatively easily change? For the most part, it's things that have to do with the owner or applicant of the trademark. The applicant's name, contact information, address, those things we can typically change pretty easily. Submit one of those voluntary amendment forms, or you can request that change in the response to an office action. Or if it has to do with your correspondence address, like your mailing address, you can use a change to correspondence address form instead. For the most part, these types of changes to the owner or applicant information can be made at pretty much any time during the application process. Outside of that though, any other changes are really going to just depend on the circumstances and the nature of the changes or amendment that you're seeking. For example, amending the mark itself. So amending or changing the actual trademark that you've put on the application. Let's say maybe you are trying to register a standard character mark and maybe you typed it in wrong, or you changed your mind later on and you actually want it to be a different trademark. With those amendments, sometimes we can do it, sometimes we can't. We're only permitted to amend the actual mark itself if the specimen or statement of use accurately reflects the amended trademark. So if we've already submitted a specimen or a statement of use showing our use of the trademark, if how we amend the trademark doesn't match how the mark appears on that specimen, then we may not be able to get that amendment through without potentially submitting a substitute specimen. So that's the first part, is the specimen or statement of use has to reflect the change in that trademark. And number two, the amendment doesn't materially alter the mark. So as long as the specimen or statement of use supports the amendment of the trademark and the amendment does not materially alter the mark, then we can typically get the amendment or that change approved through the USPTO. So what does a material alteration mean? How do we know if a change is going to be a material alteration to the mark or not? There is a test for determining if a change is a material alteration. And I'm going to read this directly from the TMEP, the Trademark Examining Practitioners Guide or rules, I don't know, TMEP. It's like where we find all the rules regarding what we do with trademark applications. I'm going to read it directly from there. The modified mark must contain what is the essence of the original mark, and the new form must create the impression of being essentially the same mark. The general test of whether an alteration is material is whether the mark would have to be republished after the alteration in order to fairly present the mark for purposes of opposition. If one mark is sufficiently different from another mark as to require republication, it would be tantamount to a new mark appropriate for a new application. So the new or proposed amended mark still has to capture the essence of the original trademark. In other words, still give the general commercial impression, the same impression that the original mark gave. So, in other words, we can sometimes make small changes to the trademark. We cannot completely change the trademark. If you submitted an application and then later decided, I want to register a different trademark altogether, you really can't go back and amend the application because it's a brand new trademark, so you have to submit a brand new application. And now is a good time to mention, this is why it's really important to at least consult with a trademark attorney if you're going to be filing the application by yourself. Because like I just said and explained, it's not that easy to make changes after the fact. Sometimes we can, but sometimes we can't. So of course it's best to have a trademark attorney do the application and assist you with the entire process so that we make sure we are doing and putting the correct information on the application. If you can't afford to work with an actual attorney, at least have someone look over your application before you submit it maybe. And you guys can check the description for links to information on my all-inclusive trademark registration package called Brand Bombshell, where we'll start with a strategy session to talk about the details of your trademark, make sure we have all the information correct, and make sure we're protecting the right trademark so we don't later have to worry about making these amendments. Or again, if working with an attorney is outside of your budget, I've also got an online DIY course called Brandish, where I teach you step-by-step how to prepare for and submit that trademark application without a lawyer. So again, you can at least know what you're doing going into it so you can avoid the need to make those amendments later on. Typically, in most situations, the addition of an element to a trademark is going to create a different commercial impression and would require republication. So in most cases, we can't add something to the trademark. Sometimes we can delete some elements, but typically adding elements isn't going to fly. Because again, the controlling question here is if this new mark and the old mark are going to give off the same commercial impression. Deleting or removing elements from the trademark may or may not be considered a material alteration. Generally, deleting or removing a kind of generic portion of the trademark isn't going to be considered a material alteration, but it could be. Let's use Lay's potato chips. Let's say they initially applied to register Lay's potato chips as their trademark, but then later on decided, we just want to be Lay's. Let's delete potato chip. Potato chips is a generic term. You can't register a trademark just for potato chips because it's generic. So if they wanted to remove potato chips and have it just be Lay's, that would most likely not be considered a material alteration. Again, it always depends on all the other factors and other things going on in that situation, but typically deleting or removing a generic component won't be considered a material alteration. Same with additions or deletions of punctuation. In a lot of cases, these won't be a material alteration. So if we wanted to add or delete a period or an exclamation point or quotation marks, hyphens, commas, in most cases, these won't affect the commercial impression of the mark. And so adding or removing them would be not a material alteration and would be approved as an amendment to the mark. But there are situations where adding or deleting a punctuation do make a difference. Let's say it's a question mark. If we have a question mark in our trademark and we want to remove that question mark, that's now changed it from a question to a statement. And again, it always depends, but in a lot of cases, changing from a question to a statement gives off a completely different commercial impression. And that likely wouldn't be a permitted amendment to the mark. Same with adding or deleting spaces between words or between syllables in the mark. Sometimes it doesn't change the commercial impression and therefore it's not a material alteration, but sometimes it does. Sometimes if we delete a space somewhere between words or syllables, it creates what's called a unitary mark, and that might be a different mark altogether. Or let's say adding or removing .com from a trademark. That makes it a statement rather than a website URL. We can sometimes amend the color descriptions if we submitted an application for a design mark like a logo and we're claiming color as a feature of the mark. Sometimes we can change those color descriptions that we're claiming in the mark. But again, it depends on the effect that that change might have on the commercial impression. If we didn't initially claim color as a feature of the mark, so we submitted a logo on the application and it's in black and white, so we're not claiming color. But if we decide, maybe we do want to claim color, in most cases, claiming color as a feature of the mark wouldn't be a material alteration and wouldn't change the commercial impression. So that change is typically going to be acceptable. Let's say we want to amend the type of trademark. Let's say we submitted it as a logo, but we decide later on, we should have done that as a standard character mark instead. Can we amend and make that change? Maybe, maybe not. Again, it comes down to, is this a material alteration of the trademark and does it change the commercial impression that it gives? If your logo that you initially submitted was just stylized text, if it was really just the words of your business name and later on you decide, I just want to register the business name without regard to style, so just a standard character mark, that might be a permissible change. Again, it kind of depends on the stage of the trademark application, where it's at as well. But if it's just a kind of stylized writing and now we want to amend it to a standard character mark, maybe. But that is a pretty big difference between a design mark and a standard character mark. So in a lot of cases, that would be considered a material alteration and that wouldn't be a permissible change. Having said that though, there's no harm in trying to submit or get something amended or get something changed on your trademark. If you want to change something, you can always submit a voluntary amendment form or submit the form to make and request that change. If the examining attorney feels that it's a material alteration, then they'll let you know and they won't make that change. If it's acceptable, then they'll accept it. It's not like requesting the change will damage the trademark through the rest of the process. There's, in most cases, no harm in trying or requesting. Now, having said that though, it's also, the earlier on in the process that you request these changes, the better. If you just submitted your application, in most cases, an examining attorney, the actual person who's going to examine and process your application, won't be assigned for about 3 months after you've submitted the application. So no one has even looked at the application for that 3-month window. If you want to make a change to your application, it's better to do it within that 3 months before anyone's even looked at it, because maybe it's a material alteration, but what's the harm in letting it go through, because we haven't even started working on this application. Again, that's not necessarily always going to be the case, but my recommendation in most situations, especially if it's kind of a reach of this might be a material change, if you can submit that early on before an examining attorney has been assigned to it, your chances of getting it approved and getting that amendment through might be a little bit higher. So we talked about making changes to the actual trademark itself. What if we need to amend something in the goods and services descriptions? So if you're not familiar, on a trademark application, we have to identify the goods and services with which we will use the trademark. If I was submitting a trademark application for my law practice, my goods and services would be something related to legal services. But we're telling the USPTO and the examining attorney what goods and services we're using this trademark with. So what if we submit the application and later realize, oh, we should have added some additional goods and services, or we should have worded it differently, or we should have done something different with the goods and services description. So again, generally speaking, we can amend a goods and services to narrow or limit the goods and services, but not to broaden them. So we can make our goods and services smaller, but we can't make them bigger. Again, let's say I submitted a trademark application for my law practice and I indicated the goods and services were legal services. But I also use the trademark in connection with my YouTube channel. After I submit the application, I can't later go back in and amend it to include educational videos, which might be the class description for YouTube videos. I don't know. It kind of depends. But I can't later add that. But I could go in and later narrow it to legal services focused on trademark registration if I wanted to, because that's limiting and narrowing the class or clarifying the goods and services. Or let's say you sell clothing items, and on the application initially you indicated the goods and services as tops as clothing. That's actually one of the descriptions. So tops as clothing. We could probably later on amend it to be tank tops, t-shirts, sweatshirts, button-up shirts. Again, clarifying or narrowing or limiting those goods and services. But we can't later on do tops as clothing and scarves and shoes and hats. Even though they're all in the same class, we're broadening that description, and in most cases, those aren't going to be permitted. But again, same with the amendments or changes to the mark itself. It doesn't really hurt to ask if you can make that amendment or to submit that request for a voluntary amendment. Worst case scenario, the examining attorney says no. And unfortunately, if they say no, then there's not much you can do. You have to either move forward with the application as it is, or you have to submit a new application. So again, this is why it's really important to make sure you have all your ducks in a row before you submit the application, because we're not going to be able to change a whole lot after the fact. Can I tell you guys, it gets kind of frustrating. I explain this to my clients, of course, when we're working on trademark applications. I make sure we have all the information correct, the details are accurate, and reflect the business intent that my clients have. And so we'll submit an application, let's say for an online, an Amazon store, and they tell me, here are the products we're going to be selling on our Amazon store. And so we include those products on the trademark application. Then a few months later, my clients come back and they say, oh, we pivoted. We decided we want to sell other types of products. We want to sell all this kinds of stuff instead. Can we change that in the application? I have to tell them, no, I don't think we can. Again, we can limit or narrow or clarify your goods and services, but we can't just after the fact add in a bunch of additional goods and services. In those situations, we have to scrap the application all over again and start from the beginning. And it's the same if they want to later change the trademark. You should be pretty solid in the trademark that you're trying to register before you submit the application, because again, we're not going to be able to change it very easily. We can make small non-material alterations, but if it's a major change, a material alteration to the trademark, we're not going to be able to do it, and we're going to just have to let the application go. You've wasted your application fees. If you paid a lawyer, you've wasted your lawyer fees, and you got to have to start from scratch from the beginning all over again. And so, of course, as with most things having to do with trademarks, it's always best to work with an attorney if you're trying to get a registered trademark with the USPTO. An attorney is going to be able to help you make sure the information's correct, the goods and services are correct. Hopefully they'll talk you through, make sure this is actually a trademark that you want to register and you don't want it to look a different way or include different elements. All those details a good trademark attorney is going to make sure we're clear on from the beginning, so we don't later on have to worry about that. If you're looking for help with your trademark application, I have an all-inclusive trademark registration package called Brand Bombshell, which includes every step of the trademark registration process, from searching to make sure the trademark's available, strategy sessions to make sure we have all the details correct, responding to office actions which commonly come up, and of course, keeping you updated on the status through the entire process. If you're looking to DIY your trademark application, I've also got my online course called Brandish, which walks you through step-by-step how to perform your own clearance search, how to decide on the appropriate goods and services for your trademark application, and then how to actually go through and submit that trademark application with the USPTO. Links to both of those are in the description. That's all for this episode, folks. Drop a comment below, let me know what you think, and again, don't forget to check the description for links to additional information and resources. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.